The Nuremberg Trials were the first open and fair proceedings in history conducted by the International Military Tribunal against prominent military criminals. In essence, these trials stand as a model of the triumph of law in interstate relations. They mark the origin of modern international law, a system of international norms that are binding not only on states, but also on the individuals who govern them. The lessons of Nuremberg remain relevant today, as revanchists and neo-Nazis are once again emerging in some countries, while certain European states attempt to promote the notion of equal responsibility between Germany and the Soviet Union, revise the status of the USSR as a victorious power to that of an aggressor, and portray the West as the savior of humanity. On September 19, 2019, the European Parliament adopted a resolution on the importance of European remembrance for the future of Europe, in which it emphasized that World War II, the most devastating war in European history, was initiated as a direct result of the infamous Nazi-Soviet Non-Aggression Pact of August 23, 1939, also known as the Molotov-Ribbentrop Pact, and its secret protocols under which two totalitarian regimes sharing the objective of world conquest divided Europe into two spheres of influence. We can confidently state that World War II was the first war whose objective was not only the seizure of territory and the subjugation of populations of other countries, but also the extermination of people based on racial, ethnic, national, and cultural characteristics, in order to create a mono-ethnic state dominated by a titular Aryan ethnicity with global supremacy. For this reason, its outcome established an entirely new form of post-war settlement, not as a peace treaty intended to reconcile conflicts, but as a judgment delivered in the name of peace. Actions that run contrary to such a treaty, including the refusal to comply with its terms, primarily entail reputational risks, whereas violation of a judgment carries an entirely different significance. The first experience in the establishment of international criminal justice was the Treaty of Versailles. After World War I, the Commission on the Responsibility of the Authors of the War and on Enforcement of Penalties, established by the Preliminary Peace Conference at its plenary session on January 25, 1919, and composed of 15 members, stated in its report of March 29, 1919, that the violations of the rights of combatants and of civilians, which primitive barbarism, drawing on all the resources of modern science, could devise to create a system of terrorism meticulously planned and carried out to completion, were egregious. The Commission concluded that all persons belonging to enemy countries, regardless of their rank, including heads of state, who are guilty of violations of the laws and customs of war or of the laws of humanity, are subject to criminal prosecution. However, the US opposed such prosecution. In a memorandum from the US members of the Commission, it was stated that judicial proceedings against a person in office were essentially proceedings against the state itself. The establishment of an International Criminal Tribunal was considered premature by the League of Nations. Nevertheless, the issue continued to attract the attention of legal theorists. On October 2, 1924, at the Fifth Assembly of the League of Nations, the Protocol on the Pacific Settlement of International Disputes, known as the Geneva Protocol, was unanimously adopted by 48 states. It stipulated that, instead of resorting to war, states undertake to seek the assistance of judicial, arbitral, and conciliatory proceedings. They commit to conscientiously comply with judicial or arbitral decisions, as well as to act in accordance with the recommendations proposed by the Council of the League of Nations. There is no doubt the protocol represented the most significant step ever taken towards the peaceful settlement of international disputes and the outlawing of aggressive wars. However, it could not enter into force until it was ratified by a majority of the permanent members of the League Council, namely the UK, France, Italy, and Japan, along with 10 other states. The Conservative government that succeeded the Labour government in the UK refused to approve the Geneva Protocol. A draft issue on an international tribunal that was developed later in 1928 and approved by the Council of the Association remained limited to formal provisions and did not define the scope of cases under its jurisdiction. An important milestone in the creation of an international criminal tribunal was the development of the concept of aggressive war. It is widely recognized that on February 6, 1933, the Soviet Draft Convention for the Definition of Aggression was presented at the Conference for the Reduction and Limitation of Armaments. Although the convention was not adopted by the League of Nations, its content served as the basis for special conventions on the definition of the aggressor, concluded by the Soviet Union in summer 1933 in London. The Soviet legal doctrine received universal recognition in the proceedings of the International Military Tribunal itself. The establishment of the International Military Tribunal was facilitated by the Soviet Union's prolonged and consistent diplomatic efforts to realize the idea of a court of nations for the principal war criminals. During the war, the Soviet Union, both independently and in coordination with its allies, issued a series of notes and statements documenting the unprecedented violence and destruction perpetrated by the Nazis in the temporarily occupied Soviet territories, while also warning about accountability for these crimes. Those who are guilty of Nazi crimes must stand trial before tribunals in each country where their atrocities were committed, in order to serve as an indelible warning to future generations, so that people may say, "Thus shall perish all who commit such crimes again." On October 7, 1942, Roosevelt issued a statement expressing readiness to cooperate with the British and other governments in establishing a Commission of the United Nations for the investigation of war crimes. A statement from the Soviet government on the responsibility of the Hitlerite invaders and their accomplices for the atrocities committed by them in the occupied countries of Europe, dated October 14, 1942, presented an interim summary of the work carried out and stated, "All responsibility for the inhumane and predatory actions of the German troops rests with the criminal Hitlerite government of Germany. It and all its accomplices must and will receive the just and severe punishment they deserve for the atrocities committed by them against the peoples of the Soviet Union and against all freedom-loving peoples in the territories temporarily occupied by the German army and its collaborators." On December 18, 1942, the governments of Belgium, the UK, the Netherlands, Greece, Luxembourg, Norway, Poland, the US, the USSR, Czechoslovakia, Yugoslavia, and the French National Committee signed the joint declaration on the extermination of the Jewish population of Europe carried out by the Hitlerite authorities. By 1942, the opinion had become firmly established among the Allies that a number of acts attributed to the German authorities in the occupied territories entailed criminal responsibility and required judicial punishment. However, at that time, the focus remained exclusively on charges of ordinary violations of the laws of war, and it was assumed that jurisdiction over such cases belonged to authorities operating within the national jurisdictions of the individual states. On October 20, 1942, the United Nations War Crimes Commission was established, which remained in operation until 1948. Additionally, in Chongqing, China, the United Nations established a sub-commission on war crimes in the Far East. By the time the commission concluded its work, it had compiled 80 lists containing 40,000 names of German, Italian, Albanian, Bulgarian, Hungarian, and Romanian war criminals, as well as 26 lists prepared by the Subcommission for the Far East and the Pacific. In this way, the idea of creating a special international tribunal before which the principal officials of the Third Reich would stand to determine their criminal responsibility was taking concrete shape. The Soviet Union was actively drafting a legal framework for the collection and documentation of evidence of fascist crimes and also refining the judicial procedures for handling such criminal cases. On November 2, 1942, the Extraordinary State Commission was established to identify and investigate the atrocities committed by the German fascist invaders and their collaborators, as well as the damage they caused to citizens, collective farms, public organizations, and state enterprises and institutions of the USSR. The materials compiled by this commission were later used during the Nuremberg Trials as evidence of the crimes committed by the Nazis on Soviet territory. By decree of the Council of People's Commissars on March 16, 1943, special commissions began to be established in the territories liberated from the occupiers. Over 7 million workers, collective farmers, engineers, technicians, scientists, and public figures participated in the compilation of investigative reports. The most important outcome of the work of the Extraordinary Commission was the compilation of lists of war criminals from the Axis countries. By October 1945, these lists include approximately 7,000 individuals, among them about 1,000 Nazis. An enormous effort was undertaken, resulting in the collection of truly unique evidentiary material. Notably, foreign judicial authorities, which had viewed Soviet justice with some skepticism, accepted the vast majority of this evidence during the Nuremberg Trials. The first trials of captured war criminals were already held in Krasnodar and Kharkov in 1943. One particularly significant military tribunal took place in Kharkov in December 15 to 18, 1943, when 2 Nazi officers, 1 Gestapo operative, and a traitor to the Soviet people were all tried. For the first time, the defendants were charged with violations of international rules and norms of warfare, including the cruel treatment of prisoners of war and civilians, as well as the mass extermination of the city's inhabitants. This tribunal was also the first to establish that following a superior's orders does not absolve one of responsibility for committing serious war crimes. All 4 defendants were sentenced to death by hanging. An important step in preparing for the future trial of the principal and other German war criminals was the declaration initiated by the Soviet Union and issued on October 30, 1943, by the governments of the USSR, the US, and the UK on the responsibility of the Hitlerites for the atrocities they committed. All German officers and soldiers, as well as members of the Nazi Party, guilty of atrocities, murders, mass executions, or other extermination of populations, shall be handed over to the countries in which these acts were committed, so that they may be tried and punished in accordance with the laws of the liberated countries and the free governments that will be established there. Thus, the 1943 declaration established not only the principle of the responsibility of the Hitlerite criminals, but also the principle of their jurisdiction. At the same time, for the principal Nazi criminals whose crimes were not tied to a specific geographic location, it was decided that their punishment would be determined by the joint decision of the Allied governments. On October 30, 1943, at the Conference of Foreign Ministers of the United Kingdom, the Soviet Union, and the United States in Moscow, the Declaration on General Security was adopted. It stated the need to establish as soon as possible a universal international organization to maintain international peace and security based on the principle of the sovereign equality of all peace-loving states, in which all such states, large and small, may become members. The Declaration of Three Powers, 1943, signed in Tehran, expressed the conviction that the consensus among the leaders of these powers would ensure a stable peace, one that would enjoy the goodwill of the overwhelming majority of the peoples of the world and banish the miseries and horrors of war for many generations. These principles guided the International Military Tribunal in Nuremberg, whose charter defined the essential elements of crimes against peace as the planning, preparation, initiation, or waging of a war of aggression or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. Regarding the content of the joint decision, opinions among the Allied powers differed significantly for a long time. They believed that the leaders of the Allied powers should compile a list of several hundred principal war criminals so that, if captured, they could be executed without trial or investigation. The Soviet Union insisted that it was necessary not only to punish the war criminals, but also to expose the anti-human nature of fascism and to examine the causes and conditions that gave rise to it. The Soviet side proposed the establishment of a public tribunal for this purpose. The sides were largely able to reach a compromise after this viewpoint began to receive firm support in the US in autumn 1944. The convergence of the US and Soviet positions helped to expand and consolidate the principles of the 1943 Declaration in the resolutions of the Yalta Conference of the Three Powers on February 11, 1945, which declared the elimination of German militarism and Nazism as their goal. On May 3, 1945, a meeting of the foreign ministers of the USSR, the US, and the UK took place during USSR People's Commissar for Foreign Affairs Molotov's visit to the US for the founding conference in San Francisco on the establishment of the United Nations. At this meeting, the American representative, US Supreme Court Justice Rosenman, presented the Soviet and UK delegations with a draft agreement on the establishment of an International Military Tribunal. The Soviet government, regarding the swift punishment of war criminals as critically important, agreed to the US government's proposal. However, it introduced a number of amendments and additions to the draft, the most significant of which was the provision that the act committed by the accused on the orders of their superior or government shall not be considered a justification for their culpability. On June 26, representatives of the four countries met in London. The US, the UK, France, and the USSR adopted the essence of the definition of crimes against peace, and they listed war crimes and crimes against humanity as separate though interrelated charges. At the London conference, the four powers also decided to include the charge of complicity in the Nuremberg Charter, agreeing that leaders, organizers, instigators, and accomplices who participate in the planning or execution of a common plan or conspiracy to commit the specified crimes are responsible for all acts committed by any persons in furtherance of such a plan. On June 5, 1945, the governments of the USSR, the UK, the US, and the Provisional Government of the French Republic signed the declaration regarding the defeat of Germany and the assumption of supreme authority by Allied powers, which served as the primary legal document outlining the conditions of Nazi Germany's surrender. The declaration identified the category of war criminals to be tried. It emphasized that the arrest and extradition of war criminals should take place at any time and that no statute of limitations applies to them. Subsequently, the list of war criminals was specified at the Potsdam Conference of the Three Powers. In particular, it was decided that Nazi leaders, war criminals, and those involved in the planning or execution of war crimes were to be arrested and brought to trial. The significance of the provisions of the International Military Tribunal Charter is underscored by the fact that they represent the first tested and successful attempt by jurists from countries with profoundly different legal systems, philosophies, and traditions to merge their concepts of fair trial procedures in order to conduct a joint judicial investigation of criminal charges. The Charter also enshrined the principle that individuals rather than states bear responsibility for criminal violations of international law, and it implies the legal principle of conspiracy to such violators, whereby anyone participating in a common plan to commit a crime becomes responsible for the actions of any other conspirator in the execution of that plan. The Charter further specified that the International Military Tribunal has jurisdiction over crimes against humanity committed before or during the war, regardless of whether such crimes constituted violations of the domestic law of the country in which they were committed. The International Military Tribunal was composed of an even number of members with 4 judges. The tribunal members presided on a rotating basis. These and many other distinctive features of the organization and functioning of the Nuremberg Tribunal contributed to the objective consideration of cases and the issuance of lawful, reasoned, and just verdicts with a relatively short time frame. 19 additional countries officially acceded to the agreement and the Nuremberg Charter. Australia, Belgium, Czechoslovakia, Denmark, Ethiopia, Greece, Haiti, Honduras, India, Luxembourg, the Netherlands, New Zealand, Norway, Panama, Paraguay, Poland, Uruguay, Venezuela, and Yugoslavia. Thus, the principles of the Charter represented the official decision of 23 governments, collectively representing approximately 900 million people. On August 29th, the first list of major war criminals was published, including the names of 24 leading Nazi figures, industrialists, military officers, diplomats, and ideologues who bore primary responsibility for all the crimes committed by the German fascists. Based on the hearings of the defendants' cases, the International Military Tribunal was to consider the question of whether to declare the following organizations as criminal: the government's cabinet, the leadership of the NSDAP, the NSDAP security squads, the SS, including the security service, the SD, the state secret police, the Gestapo, the NSDAP stormtroopers, the SA, and the General Staff and High Command of the German Armed Forces. The International Military Tribunal was formed on a parity basis, with representatives from the four great powers. The chief prosecutors were prosecutor of the Ukrainian SSR Rudenko from the USSR, former aide to President Roosevelt and U.S. Supreme Court Associate Justice Jackson from the U.S., Attorney General and Member of Parliament Shawcross from the UK, and Minister of Justice de Menton from France, who was later succeeded by Jean-Pierre de Rib. To coordinate the actions of the chief prosecutors at the Nuremberg Trials of the major German war criminals, a prosecutors' committee was established and composed of the chief prosecutors from the USSR, the UK, the US, and France, or their deputies. At the Nuremberg Trials, the main types of evidence presented by the prosecution were documents and testimony of defendants and witnesses. The task of the Soviet prosecution in preparing evidence was greatly facilitated by the extensive materials collected during the war by the Extraordinary State Commission for the Establishment and Investigation of the Atrocities of the German fascist invaders and their accomplices. 32,000 doctors, engineers, educators, and public figures actively participated in documenting the atrocities and destruction committed by the German fascist invaders. In accordance with Article 21 of the Charter, the acts of the Extraordinary Commission were considered indisputable and were to be accepted by the tribunal without further proof. These materials alone provided the Soviet prosecution with enormous evidentiary value and ensured the presentation of the case on behalf of the USSR against the major German war criminals. Similar materials were submitted to the International Military Tribunal by the governments of Poland, Czechoslovakia, Norway, and several others. The governments of the US, the UK, and France also had access to a large amount of documentary evidence exposing the major German war criminals for the atrocities they had committed. As the German forces retreated under the crushing blows of the Red Army, they evacuated a significant portion of the most valuable archives to the territory of Western Germany, which were subsequently seized by Anglo-American forces. The US delegation at the Nuremberg Trials claimed priority in conducting the interrogations of defendants and witnesses. The US delegation maintained that only American investigators should question the defendants and witnesses under their control, while other delegations could pose their questions through these American investigators and receive the corresponding answers in writing. This position was supported by the chief prosecutors from the UK and France. The Soviet delegation lodged a firm protest against the stance taken by the US delegation and insisted on being granted the right to examine all necessary witnesses prior to the trial. This legitimate demand was granted. The proceedings of the International Military Tribunal were held from November 20th, 1945 to October 1st, 1946 at the Palace of Justice in Nuremberg. The president of the International Military Tribunal, Lord Lawrence, formally opened the first session. In doing so, he emphasized, "The trial that is now to begin is unique in the history of world jurisprudence. and it carries the greatest public significance for millions of people across the globe. For this reason, an immense responsibility rests upon everyone participating in these proceedings. 24 defendants were brought before the tribunal. Reichsmarshal and Commander-in-Chief of the German Air Force, Göring, Hitler's deputy in the leadership of the Nazi Party, Hess, foreign ministers of the Third Reich, von Ribbentrop and von Neurath, Chief of Staff of the High Command of the Wehrmacht, Keitel, Chief of the Security Police and SD, Kaltenbrunner, Hitler's deputy for ideological training of party members and Reich Minister for the occupied Eastern Territories, Rosenberg, Governor General of occupied Polish territories, Frank, Reich Minister of the Interior, Frick, Organizer of anti-Jewish pogroms, Streicher, Ministers of Economics, Schacht and Funk, Commanders-in-Chief of the German Navy, Dönitz and Ryder, Hitler Youth Organizer and Leader von Schirach, General Plenipotentiary for Labour Deployment, Saukel, Keitel's deputy and one of his closest advisors, Jodl, one of the active organizers of the Nazi seizure of power, von Papen, Governor of Austria, occupied Poland and the Netherlands, Seyss-Inquart, Reich Minister of Armaments and War Production, Speer, Head of the Department of Domestic Press of the Ministry of Propaganda, Fritzsche, Head of the Nazi Party, Chancellery and Hitler's personal secretary, Bormann, Head of the Organizational Department of the NSDAP, Ley, and Chairman of the Board of the Imperial Federation of German Industry, Krupp. The defendants did not include those who had committed suicide. Adolf Hitler, the founder of National Socialism, architect of the totalitarian dictatorship of the Third Reich, and supreme commander of Germany's armed forces during World War II, Goebbels, Reich Minister of Public Enlightenment and Propaganda of Germany, and the NSDAP's imperial propaganda leader, and Himmler, Reich Minister of the Interior of Germany and Chief of the RSHA. The following acts, or any of them, were declared to fall under the jurisdiction of the tribunal as crimes for which individual responsibility was established. Crimes against peace, namely planning, preparation, initiation or waging of a war of aggression or a war in violation of international treaties, agreements or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. War crimes, namely violations of the laws or customs of war. Such violations shall include, but not be limited to, murder, ill treatment or deportation to slave labor or for any other purpose of civilian population of or in occupied territory, murder or ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, wanton destruction of cities, towns or villages, or devastation not justified by military necessity. Crimes against humanity, namely murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country where perpetrated. The tribunal also addressed the question of whether to declare the following organizations as criminal: the government, the General Staff and High Command of the Wehrmacht, and the leadership of the party, including the security service, the stormtroopers, and the Gestapo. The essence of the charges brought was vividly and strikingly articulated in his opening statement to the court on February 8, 1946, by the Soviet representative Rudenko.
В этот день началось выступление советского обвинения, главный обвинитель от СССР товарищ Руденко.
Господа судьи, я приступаю к своей вступительной речи, завершающей первые выступления главных обвинителей на данном процессе, в полном сознании его величайшего исторического значения. Впервые в истории человечества правосудие сталкивается преступлениями такого масштаба, вызвавшими такие тяжелые последствия. Впервые перед судом предстали преступники, завладевшие целым государством, и самое государство, делавшее орудием своих чудовищных преступлений.
От имени Советского Союза я предъявляю подсудимым обвинение по всем пунктам статьи 6 Устава Международного военного трибунала во имя священной памяти миллионов невинных жертв фашистского террора, во имя укрепления мира во всем мире, во имя безопасности народов в будущем, мы предъявляем подсудимым полный и справедливый счет. Пусть же свершится правосудие.
A regime founded on the disregard for the elementary principles of humanity. Now, when as a result of the heroic struggle of the Red Arms and of the Allied forces, Hitlerite Germany is broken and overwhelmed, we have no right to forget the victims who have suffered. We have no right to leave unpunished those who organized and were guilty of monstrous crimes in sacred memory of millions of innocent victims of the fascist terror. For the sake of the consolidation of peace throughout the world, for the sake of the future security of nations, we are presenting the defendants with a just and complete account, which must be settled. This is an account on behalf of all mankind, an account backed by the will and the conscience of all freedom-loving nations. May justice be done. At some convenient opportunity, concluded a treaty of non-aggression with the Union of Soviet Socialist Republics. During the Nuremberg Trials, it was inconceivable for anyone to regard the foreign policy of the Soviet Union as anything other than committed to peace. An important aspect of Shawcross's speech on December 4th, 1945, was the thorough elaboration of the concept of individual responsibility of German officials and businessmen for Nazi crimes. These are the men who enabled Hitler to build up the army, the navy, the air force, the war economy, the political philosophy by which these treacherous acts were carried out, and by which he was able to lead his fanatical followers into peaceful countries to murder, to loot, and to destroy. The opening statement of France's chief prosecutor, François de Menthon, delivered at the session of the International Military Tribunal on January 17, 1946, called to punish the leaders of Germany who bear responsibility for this. If they are not condemned, if justice is not carried out, the peoples will lose faith in the possibility of justice being realized. The Nuremberg trials were open and public in the broadest sense. Over the 316 days of proceedings, 403 public sessions were held. More than 60,000 passes were issued for admission to the courtroom. The trial transcripts comprised nearly 40 volumes containing over 20,000 pages. Proceedings were conducted simultaneously in 4 languages: Russian, English, French, and German. Approximately 250 reporters from the press and radio were present in the courtroom each day. The tribunal heard the testimony of 33 prosecution witnesses and 80 witnesses for individual defendants, including 19 of the defendants themselves. An additional 143 witnesses for individual defendants provided written answers to interrogatories, and 1,809 submitted written statements. The tribunal heard 22 witnesses for the defendant organizations and appointed a commission to examine 100 witnesses for such organizations. A total of 1,809 statements were submitted on behalf of the defendant organizations. In addition, several thousand documents were received as evidence, most of which were read aloud into the record. More than 100,000 seized German documents were preserved and analyzed. Of the 10% that were carefully examined, approximately 4,000 were authenticated, translated into 4 languages, and used in whole or in part as evidence. Another 30 kilometers of film and 25,000 photographs selected by the prosecution should be added to this. At the Nuremberg Trials, the defendants exercised their procedural guarantees and rights in full, without any restrictions. They were defended by 27 lawyers and assisted by 54 legal aids and 67 secretaries. The defense included numerous prominent attorneys from former Nazi Germany, such as Dix, Starmer, Exner, Kranzbühler, and others. The defense was provided with office space and an information center, where the prosecution submitted 6 copies of each document it presented to the court as evidence. The prosecution presented the court with an enormous amount of evidence that was exceptional in its thoroughness and strength. Transcripts of meetings with Hitler, orders from the High Command of the Wehrmacht, various instructions, and thousands of other documents from the archives of the Reich Chancellery, the Foreign Ministry, military headquarters, and the personal archives of the defendants, as well as confidential correspondence of German industrial concerns, all of which was subjected to judicial examination. The Soviet prosecution submitted 520 documents, of which more than 60 consisted of acts and reports of the Extraordinary State Commission, and verdicts in cases of war criminals who committed atrocities in the Kharkov, Krasnodar, Smolensk, Bryansk, Oryol, Nikolaev, and Leningrad regions, as well as the verdict of the Bulgarian People's Court. The documentary evidence presented by the Soviet prosecution for sections 1 and 2 of the indictment was primarily official in nature and originated from the defendants and their accomplices. Notes, reports, memoranda, letters, instructions, orders, directives, meeting protocols, records of conversations, treaties, and agreements. In addition, documents such as speeches at congresses, sessions of the Reichstag, radio broadcasts, newspaper and magazine articles, books, geographical maps, diagrams, and plans were widely used. Personal correspondence, diaries, and memoirs also played a role, in particular correspondence between Göring and Rosenberg, the multi-volume diary of Anne Frank, and more. For sections 3 and 4, the primary evidence consisted of reports and acts of the Extraordinary State Commission. Photographic and film materials, including those shot by the Nazis themselves, also played an important role. Notably, a fascist film depicting the destruction of the Czechoslovak village of Lidice was presented, as well as documentary films on the crimes in Danzig, Auschwitz, and Majdanek, the destruction of Smolensk, the destruction of cultural and artistic monuments, photographic evidence of war crimes in Latvia and Lvov, the destruction of churches, and the concentration camps of Majdanek and Auschwitz, among others. The Soviet delegation also presented physical evidence. Significant importance was attached to written testimonies and statements from victims and witnesses, both citizens of the anti-Hitler coalition countries and Germans. The Soviet prosecution also presented evidence of crimes committed in Czechoslovakia, Poland, Yugoslavia, Norway, and Greece. The prosecution's documents presented at the trial provided irrefutable evidence that all acts of fascist aggression had been planned and prepared long before their execution. Other significant evidence included the testimony of individuals who held high positions in the command of the fascist army and intelligence, such as Paulus, Lahusen, Gizavius, and others. In several instances, the tribunal members diverged in their views on conceptual issues of international law. Concepts such as common plan or conspiracy, crimes against humanity, and the question of declaring the organizations of the Hitler government, the High Command, and the General Staff as criminal were the subject of intense discussion. The method of execution for the condemned was also a matter of debate. Should they be hanged, a humiliating death, or shot, a soldier's death? The French judge advocated execution by shooting exclusively for military personnel. Ultimately, execution by hanging was decided. On September 30th to October 1st, 1946, the judgment was pronounced. The International Military Tribunal ruled that aggression was the supreme international crime. For the first time in history, heads of state were punished as criminal offenders for preparing, initiating, and waging an aggressive war, thereby introducing the principle, the position of an individual as head of state or a high-ranking official in government agencies, as well as the fact that they acted on government orders or carried out a criminal command, does not constitute grounds for exemption from responsibility. The International Military Tribunal sentenced Göring, von Ribbentrop, Keitel, Kaltenbrunner, Rosenberg, Frank, Frick, Streicher, Saukel, Jodl, Seyss-Inquart, and Bormann in absentia to death by hanging. Hess, Funk, Ryder to life imprisonment, von Schirach and Speer to 20 years, von Neurath to 15 years, and Donitz to 10 years of imprisonment. Fritzsche, von Papen, and Schacht were acquitted. The leadership of the NSDAP, the SS, the SD, and the Gestapo were declared criminal organizations. Soviet Judge Nikitchenko submitted a dissenting opinion, an integral part of the judgment, in which he objected to the acquittal of Fritzsche, Papen, and Schacht, the non-recognition of the German cabinet, the General Staff, and the High Command of the Wehrmacht as criminal organizations, as well as the sentence of life imprisonment instead of the death penalty for Hess. The execution of the major war criminals was scheduled, and the sentence was carried out on October 16, 1946. Göring committed suicide prior to his execution. The overall outcomes of the trial received high praise in the USSR. On October 2, 1946, Pravda published an article titled "The Verdict of History," which stated, "The court has exposed and branded as the gravest crimes the insane, bloody plans of the German fascist aggressors who prepared, organized, and ignited World War II. The verdict of history has been delivered." Robert Jackson summarized the tribunal's outcome. "We have documented from German sources the Nazi aggressors, persecutions, and atrocities with such authenticity and in such detail that there can be no responsible denial of these crimes in the future, and no tradition of martyrdom of the Nazi leaders can arise among informed people. The principles of international law recognized by the Charter of the International Military Tribunal and reflected in its judgment were affirmed by the United Nations General Assembly Resolution of December 11, 1946. Affirmation of the principles of international law recognized by the Charter of the Nuremberg Tribunal and further elaborated upon in the UN General Assembly Resolution of November 21, 1947, Draft Code and Offences Against the Peace Security of Mankind, formulation of the principles recognized by the Charter of the Nuremberg Tribunal and reflected in its judgment. The decisions of the International Military Trials became the legal foundation for dozens of major international conventions, collectively known as international humanitarian law and the law of international security. The Nuremberg Trials represented one of the most important political and legal outcomes of the defeat of Nazi Germany. Its historical significance lies in the fact that, for the first time in the history of international relations, it brought an end to the impunity of aggression and aggressors in the context of criminal law. At the same time, the anticipated trial of the criminal leaders of German monopolies, in whose interests aggressive wars were waged and entire countries enslaved, did not take place, nor were international trials held for other major war criminals from European Axis countries. The International Military Tribunal ceased to exist in October 1946, contrary to its charter.